Meron akong tanong. Pwede mo bang i-post at i-discuss sa social media o sa mainstream media ang disbarment complaint laban sa isang abogado? Ano ba ang nakasaad sa batas o sa rules ng Supreme Court ukol dito? Section 1, Canon 6 of the Code of Professional Responsibility and Accountability states, Nature of disciplinary proceedings against lawyers. Disciplinary proceedings against lawyers shall be confidential in character and summary in nature. Nonetheless, the final order of the Supreme Court shall be published like its decisions in other cases. We also have Section 44 under the same canon. Confidentiality. Proceedings against lawyers shall be confidential. However, the final order of the Supreme Court shall be published like its decisions in other cases. Sa Section 18, Rule 139B naman ng Rules of Court, ito po ang nakasaad. Section 18, Confidentiality. Proceedings against attorneys shall be private and confidential. However, the final order of the Supreme Court shall be published like its decisions in other cases. So you will notice po na sa tatlong provisions na ito, paulit-ulit na ini-emphasize ng Supreme Court na ang disciplinary proceedings against lawyers are confidential in character. Sa nasabing Section 1, to repeat, disciplinary proceedings against lawyers shall be confidential in character and summary in nature. Sa Section 44 naman, proceedings against lawyers shall be confidential. Tapos sa Section 18, Rule 139B, ito naman ang nakasaad. Proceedings against attorneys shall be private and confidential. Ano ba ang ibig sabihin ng confidential? Sa Google Dictionary, the word confidential is an adjective which means intended to be kept secret. Sa Merriam-Webster Online Dictionary naman, it means that it is intended for or restricted to the use of a particular person, group, or class. Sa Black's Law Dictionary naman, the term confidential means entrusted with the confidence of another or with his secret affairs or purposes. So ang meaning pala ng confidential as applied to disciplinary proceedings against lawyers ay habang nakabinbin pa ang disbarment case o habang iniimbestigahan pa ito o habang wala pang lumalabas na desisyon ang Supreme Court, hindi pwedeng pag-usapan ang nilalaman ng disbarment complaint o ang merito nito sa public, sa social media, o sa print, radio, or broadcast media. Ano ba ang rasyonale o dahilan bakit pinagbabawalan na pag-usapan ito? Inexplain po ng Supreme Court in the case of Saludo Jr. versus Court of Appeals at sinight uli sa kaso ni Fortune versus Quinsayas ang rason bakit kailangan na confidential ang disbarment proceedings. Ito po ang sabi. The purpose of the rule is not only to enable this court to make its investigations free from any extraneous influence or interference, but also to protect the personal and professional reputation of attorneys and judges from the baseless charges of disgruntled, vindictive, and irresponsible clients and litigants. It is also to deter the press from publishing administrative cases or portions thereto without authority. We have ruled that malicious and unauthorized publication or verbatim reproduction of administrative complaints against lawyers in newspapers by editors and or reporters may be actionable. Such premature publication constitutes a contempt of court, punishable by either a fine or imprisonment or both at the discretion of the court. So ang dahilan pala kung bakit confidential ang disbarment proceedings ay, number 1, para hindi maimpluwensyahan o panghimasukan ang ginagawang investigasyon ng IBP o ng Supreme Court. Second, para maprotektahan ang reputasyon ng abogadong sinampahan ng disbarment. And third, para pigilan ang press na i-publish ang nilalaman ng disbarment case nang walang pahintulot ng Korte Suprema. Question: Is the confidentiality rule absolute? Meaning to say, wala bang mga exceptions o mga instances na pwedeng isapubliko ang disbarment case na kinakaharap ng isang abogado? The answer is no. Ayon mismo sa Korte Suprema, the confidentiality in disciplinary actions for lawyers is not absolute. It is not to be applied under any circumstance to all disclosures of any nature. Meron pong tinatawag na exceptions sa confidentiality rule. Una, if there is a legitimate public interest involved in the disbarment complaint, the media is not prohibited from making a fair, true, and accurate news report of a disbarment complaint. Pero paalala po, fair, true, and accurate news report of a disbarment complaint lang ang pwedeng ilabas ng media. Ibig sabihin, dapat walang comments o remarks. Bawal pa rin po i-discuss sa media ang merito ng kaso, like for example, opinion, kung karapat-dapat bang i-disbar o hindi i-disbar ang isang abogado. However, in that same case in Fortune, sinabi ng Supreme Court na in the absence of a legitimate public interest in a disbarment complaint, members of the media must preserve the confidentiality of disbarment proceedings during its pendency. Disciplinary proceedings against lawyers must still remain private and confidential until their final determination. But even for example, may legitimate public interest involved ang isang disbarment complaint, bawal pa rin na mag-distribute ng kopya ng disbarment complaint gaya ng ginawa ni Attorney Quinsayas in the case of Fortune versus Quinsayas et al. Ito po ang sabi ng Supreme Court. Attorney Quinsayas is bound by Section 18, Rule 139B of the Rules of Court, both as complainant in the disbarment case against petitioner and as a lawyer. As a lawyer and an officer of the court, Attorney Quinsayas is familiar with the confidential nature of disbarment proceedings. However, instead of preserving its confidentiality, Attorney Quinsayas disseminated copies of the disbarment complaint against petitioner to members of the media, which act constitutes contempt of court. Ganito rin ang nangyari kay Attorney Relativo in the case of Relativo versus De Leon, when he caused the publication in newspapers of statements regarding the filing and pendency of the disbarment proceedings. The court found him guilty of contempt. By the way, ano ba ang example ng isang disbarment complaint na imbued with public interest? In the case po of Fortune versus Quinsayas et al., the Supreme Court said that the filing of a disbarment complaint against Attorney Fortune is itself a matter of public concern, considering that it arose from his involvement and participation as defense counsel in the Maguindanao massacre case. Attorney Fortune allegedly used and abused legal remedies available and allowed under the rules, muddled the issues, and diverted the attention away from the main subject matter of the cases. In so doing, Attorney Fortune diminished the public confidence in the law and the legal profession, rendering him unfit to be called a member of the bar. Yan po ay ayon sa complaint, sa disbarment complaint na ifinay laban sa kanya. So, kaya po, according to the Supreme Court, imbued with public interest ang disbarment complaint laban kay Fortune dahil may connection ito sa pagiging defense counsel niya in the Maguindanao massacre case. We now go to the second exception. Ano ba itong second exception? It will not violate the confidentiality rule if a lawyer was merely compelled to attach the disbarment complaint as part of his client's answer in order to establish motive. That is, to show that the case filed against his client was merely the opposing lawyer's way of revenge for filing a disbarment complaint against her. This is the case po of Guanzon versus Duhilio. In that case, the Supreme Court said that Attorney Duhilio is not liable for violation of the Code of Professional Responsibility and the Rules of Court on confidentiality of disbarment proceedings. It observed that Attorney Duhilio as counsel merely found it necessary to submit the said documents, yung disbarment complaint po, in order to defend his client by establishing Attorney Guanzon's real motive in filing the civil and criminal cases against his client. I am referring to Attorney Duhilio's client. Question. Alam na natin na ang purpose ng confidentiality rule is para maprotektahan ang reputasyon ng abogadong sinampahan ng disbarment. Pero what if ang lawyer mismo na sinampahan ng disbarment ang mag-publish ng disbarment complaint niya at i-discuss ito sa social media? Violation din ba ito ng confidentiality rule? The answer po is yes. Ang purpose po ng confidentiality rule is hindi lang para protektahan ang reputasyon ng abogado na sinampahan ng disbarment complaint. Kung mas pipiliin ng abogado na isapubliko ang kaso niya sa social media for whatever motive, dapat pa rin isaalang-alang ng abogado na ang layunin ng confidentiality rule ay para hindi maimpluwensyahan o panghimasukan ng publiko ang ginagawang investigasyon ng IBP sa disbarment complaint laban sa kanya. To reiterate, disbarment proceedings against lawyers are private and confidential. Tanging ang Supreme Court lamang po, pagtapos na ang investigasyon at mayroon ng desisyon, ang maaaring magsapubliko ng disbarment proceedings. Now, ano ba ang parusa pag napatunayang lumabag ang kahit sino sa confidentiality rule ng Supreme Court? The Supreme Court po can cite the person concerned for indirect contempt and impose on such person a penalty of fine not exceeding 30,000 pesos or imprisonment not exceeding 6 months, or both such imprisonment and fine at the discretion of the Supreme Court. So hanggang dito lang po muna tayo, and kung may tanong po kayo, please hit the comment section. Maraming salamat po.